I say this a lot. I think everyone at the firm just is done hearing about it. But we need to work harder than the police, the investigators, the district attorney's offices. We have to build our own case and not rely on the evidence that was gathered for their case. We've had an SA case ended up going to trial, and just looking at the discovery, it did not make sense. We got ordered subpoenas, the complainant's phones, the eyewitnesses' phones, because the police didn't bother getting it. What we got was a video of one of the complainants and the eyewitnesses after this alleged SA pole dancing. Pole dancing at home, having a grand old time, laughing, giggling. It looked like a blast. The complainant and the eyewitnesses testified at trial. They all said, we were so scared. We went home, did not really know what to do. We're very young here. We fell asleep and we decided to call the police the next day. No mention of dancing, no mention of this video. My colleague, my co-defendant's counsel, who's like a dad, he's this wholesome man, probably church-going wholesome man, who proceeds to ask the eyewitness the pole in her bedroom, what that pole is used for, gets her to say pole dancing, and then asks her, well, after the SA, wasn't there just pole dancing? Victims don't act a certain way after an SA, and I get all that. But this thing was completely left out of the narrative of what happened that night and why they waited to call the police. And so we played the video for the jury after getting the eyewitness to say there was dancing, there was pole dancing. This was the most powerful piece of evidence that we had to completely refute the claims that were raised against our clients. And it was a not guilty. So we always have to work harder than the other team.